decision was 4-1, and the Supreme Court, it was 5-2. And now, it's in the East African Court of Justice. As a matter of fact, if it wasn't for this colloquium, we would be in Arusha trying to defend that. So what are we trying to say? The work that you do, while the politicians are the real representatives of the people, you are the voice, and you should maintain the spirit of the people of your nations. What else has been tested? And I told you I came to confirm the fears highlighted by Sheriff Sam. It has gone as far as the security of tenure of the members of parliament. While you come from your various jurisdictions, the first service is to the people, but the bigger service is to the institution that you serve. There is a case that has come to be known as the Rebel MP case, where members of parliament were being gagged from free speech within their parties. And when they decided to speak out, they were dismissed from their parties. And as parliament, the speaker was tasked to expel those people from the house. Part of the roles of legal counsel, where I come from, is to guide in the drafting of rulings. And the speaker came up and said, she's not clothed with authority to dismiss these people. What did the Attorney General do? He wrote a very long opinion, I think around 15 pages, saying the speaker was wrong and should have dismissed these people. The civil society came up, the matter ended up in court. 4 cases on the same issue. They were consolidated, and that's when Parliament started standing on its own, because the Constitutional Court found the Speaker at fault, but the Speaker was vindicated by the Supreme Court. And that's where the doctrine of separation of powers got anchored at that time. We were vindicated in our decision, we were vindicated in our advice. But not many people will understand that. The other problem is what we call the executive dominance. They always want to be the big brother. I don't understand big brother, but I think it is somewhere here. They want to be the big brother, and they will always find a way. Back to my first point, tact is required. Tact in whatever you do. Let me share this, and probably it is the first time I am sharing it, and please, maybe boss, you close your ears for this one. When our members were going to be dismissed, we had to find a way of protecting them. And what did we do? They had filed an appeal. The application to stay execution of the decision was 4 days away. These guys had secured an order to evict the gentleman. So we sat and said, what do we do? Tact. We wrote to court and told them we don't understand your decision. Can you please interpret? That bought us 2 days. And on the 4th day, when they wanted to evict them by force, they got an order keeping them in. So you find every possible way to protect your members. Every possible way. Way back in the early 2000s, there's a decision, General Tumukunde versus the Attorney General. General Tumukunde, this guy was forced to resign, not of his own volition, but was forced to resign. And our Supreme Court came up and laid the law that the duty of the Speaker is none but to her members. And they cited the renowned English phrase, the Speaker has no eyes to see, nor the ears to hear, other than as directed by the House. We have no eyes, nor the ears, nor the hands to do, other than as directed by the constitutions of our country, the rules of procedure, and the people of Uganda, or the people of Africa right now. The moment we master that, then we are doing a service to our nations. Sheriff Sam talked about that slide 11. Let's go to 10. That slide 11. They will attack the legislative role, and I've illustrated that through the constitutional petition. through the rebel MP's petition, the oversight role, last month alone, Sheriff Sam was talking about 50. I think he still takes the medal. Last month alone, we received 3, targeting the oversight and trying to stifle Parliament in carrying out its oversight. The first one was a probe against a probe of the central bank and its role in the closure of commercial banks. The central bank had never, and I repeat, never been opened as wide as it was by Parliament. And that's when the people of Uganda got to learn how their central bank is run and how the financial institutions were being killed, others strangled by the stroke of a pen. Right now we're in court. We wait the adjudication. The other, in that regard, if you've read about where I come from, there's something called the Golden Handshake, where guys did their job and they got rewarded 5 billion shillings. 5 billion for doing what you're hired to do. So again, Parliament intervened, and we're in court. We await a decision on that. On vetting, we have also been in court, and the problem here is that our rules of procedure require that the proceedings of that committee are held behind closed doors, and the report is only given to the president, who is the appointing authority. So yes, a fellow member took us to court and said, look guys, I need to know why you rejected me. I need to know the reasons for your rejection. And the moment you give that, one, you not only have breached the rules of procedure, but you'll have subjected that decision to the processes of judicial review. So we said, you know what? Take us to court. We cannot give it to you. And luckily on that time, not luckily, a lot of work was put in, and that we won. On the other role of privileges, right now we've got a matter where the journalists, going about the groups you're talking about, the journalists under the Parliamentary Press Association has taken us to court. Why? Because the Speaker exercised the privilege and power given to her under the Powers and Privileges Act. Every angle is under attack, and the institution's survival rests on you. And that's why I said I'll concentrate here. House procedures, we've had 2 bad cases, and they have said that since the rules of procedure emanate from the Constitution, a breach of the provisions of the rules of procedure is a breach or a violation of that constitutional article. And therefore, anything done as a consequence is null and void. That's where we are. We've gone through that, Supreme Court, Constitutional Court. That's it. I would give you a whole list, but Sheriff Sam told me you should not speak for a longer period than I did, so I have to protect myself. On other parliamentary matters, this is where the administration comes in. We never studied human rights in law school. It's not an easy task. Where members of Parliament's rights, as an attempt to muzzle them by the executive, are suffocated, they are arrested, they are beaten. Oh, by the way, we have a medal in that. Arrested and are beaten. And you've got to be the Jesus to try and save the day. These things all rest on your shoulders. What have we done about it? Sitting here and reading the Book of Lamentations does not help. But the Parliament of Uganda has taken a step. It has appreciated the challenge that is posed by it, and has opted to reorganize the services. It has opted to reorganize the services to allow the creation of 2 departments, legislation and procedure services, and then the litigation and compliance, so that it can sufficiently tackle the challenges of the day. I didn't see a person from Nigeria, but one of them said that when the hunters learn to shoot without missing, the birds learn to fly without perching. So when you attack us, when we are under challenge, how do we best serve our institutions? We've decided to reorganize the services. As part of it, we've decided to make more provision, financial or otherwise, human resource, and the management of the institution has been gracious enough to facilitate that. And they've realized that the legal services of Parliament cannot be treated as services of any other corporate entity. And they've, in their wisdom, said the reporting lines are only to the Chief Executive and to the presiding officers of the House. That way, everything is done within perspective. Now, the gentleman wants me to stop, but we still have some more challenges. The executive handcuffs. Right now, the private members' bills are under attack. We cannot introduce a private member's bill that imposes a charge on the consolidated fund. And now that's the handcuff we have to deal with. We can share and see how we go about it. We fought this up to the Supreme Court, and we've not gotten reprieve. So that's an area where I will invite you to share the ideas, but it's by constitutional command. As we share, let's see how this happens. Well, haven't I spoken a lot? Oh, the other thing. The reliance on decisions from other jurisdictions have introduced new things in our legal regime. I already talked about the public participation. There is a new animal called basic structure doctrine, to the effect that the members of Parliament, though clothed with authority to legislate, cannot touch certain pillars of the Constitution unless the same is done with the people's blessing. And where was it coined? In the Indian Supreme Court. From there it traveled to Germany. It came to Africa through Tanzania, which rejected it. Went to Kenya, and all of a sudden it is in Uganda. I don't know where it will end up next. So these are some of the things we've got to look at. We had an issue of nomination of members. That came from Malawi and traveled all the way to Uganda. That you couldn't get nominated as an independent if you've previously been, or if you elected on a party ticket. Or you couldn't be nominated as a party member if you're previously elected as an independent. That we managed to solve by constitutional amendment. But I'm not so sure it will not come to your jurisdictions. What am I saying? Let's be on the lookout. Let's advise. And going by the challenge that the Vice President said, whether you'll keep your job after advising. 3 words: document, document, document. That will be a judge at the end of the day. I thank you.
Thank you very much to our colleagues for such thought-provoking presentations. And now we're going to start with the most exciting part, where we all participate through questions. And both our representatives here will note and come to the podium to come and answer to some of those questions. There have been key issues that have been raised. I don't think this is necessary because lawyers have been taking notes throughout this period, but I also have to do my part in the process. So I'll just make a small summary of what the key issues that our colleagues have touched on, which I think we're very much familiar with as practitioners in this space. One of the most critical, which has been spoken about since this morning by the Vice President and the President of the Colloquium, is the issue of public participation as an imperative for a functional and effective Parliament. Public participation in the lawmaking process. The second issue which has been raised as a thread right through the presentations by our colleagues here is the issue of the separation of powers between the different branches of the state, the role of the courts versus that of Parliament or the legislature. They've also spoken to the issue of locus standi to enforce the Bill of Rights, including the right for people to participate in the lawmaking process and other processes of Parliament. They also spoke about the truncated time period, which leads to representatives in our parliaments pushing legislation as quickly as possible within the period that they are in government. And this leading to various procedural issues which end up in the courts and decisions of the courts criticizing Parliament for its failure to adhere to the principle of public participation. They've spoken to the issue of capacity challenges. They've also spoken to the issue of effective oversight, what our parliaments need to do in order for them to exercise their obligation to exercise effective oversight over the parts of the executive. And as well as the court's role in usurping, in line with the principle of separation of powers, and to the extent which the courts end up usurping that power because parliaments are really not being so successful in exercising that role. And lastly, and more importantly, the issue of internal organization of the institutions in order to ensure that the work of legal counsel is very much effective and efficient. From now on, then, we'll be taking questions from colleagues. I would like to take as many questions as possible to hear from many of the jurisdictions as possible in order to learn what is best practice in line with the theme of this presentation. Thank you. We're taking questions now. Sir, number one. You put number one, sir. Thank you.
Yes, so my question is, I believe, to colleague from Uganda. So my general understanding, legal office, and in Ghana, legal office is not even a year old, so we are yet to learn some of these things. But my understanding is oftentimes the legal office is supposed to provide a shield and deal with litigation when they come. But the impression I'm getting from you is that certain times you would be taking the initiative and, as it were, acting as the sword. And I wanted you to speak a bit on circumstances under which the legal counsel would have to be preemptive and act to protect the interests of Parliament or the House. And if you can share some of these examples.
Thank you, sir. Any other question? Yes, ma'am, please go ahead. Please use your next one if that one's not working.
Okay, yeah. Thank you very much, Mr. Mwendwa. My question is directed, not really a question, it's a discourse. The litigation challenge and best practices. I'm excited about what you've shared. I look forward to actually reading slide by slide. And I'm asking myself, we are legal counsel, we are sitting on these committees, we are sitting in Parliament as they're passing these decisions, we are guiding members all through with these bills, and the colloquium is that forum where we actually share the best practices. So what are we doing? I'd like to hear from the colleagues around how we are actually protecting Parliament against this litigation challenge. What are we doing? I would like to hear from Kenya, the cases that have been decided. What have you now done in terms of bill analysis? I would like to share your like templates. You must have something like a checklist that we are checking out against this, because the courts have decided this way. This is what we are doing. So that as we are sitting in these committees, we are alive to the procedure, we are alive to litigation challenge. So if you could share some of those, what you have done as an office, what you have done as a result of the court, the judgments that have arisen from court. That is my contribution.
Thank you, sir. My name is Lunga Dlamini from Eswatini. From my general observations when it comes to issues of litigation against Parliament, in most instances, I don't know from other jurisdictions, in most instances, litigation comes about internally as opposed to external litigation. You may find that politicians themselves, through political frustrations, through the unequal or uncertain application of the doctrine of privileges and immunities, you may find that They are the ones going out to court, bringing litigation challenges on the doctrine of privileges. So my interest is on the aspect of privileges, whereby members would feel, they are frustrated due to the doctrine of privileges. They are not given adequate audience for them to voice out their expression, opinion, You find that, presiding officers or the leading party or the majority party will be using the doctrine of privileges and also taking honorable members to disciplinary committees just to frustrate them. Hence, the need to go to external remedies like in courts. I just want to know from other jurisdictions how they deal with such issues.
My name is Rusan Tinda. I'm here on behalf, together with Ada, but my job basically back home in Namibia, I'm the chief researcher at the Law Reform and Development Commission. Our job is mostly to consolidate and reform the law, and 90% of our work is through public consultation. Nothing can go to parliament without that. But my question is, how do you bridge the link, or how do you bring about that link between law reform and parliament? Because that's where the problem is. Because then some of the ministers decide, I want to pass a bill on mental health, for instance. So that whole ministry works on a bill by themselves and just take it to parliament, and then they bypass law reform on the side. And then when they now want to defend it, then they go, okay, we need your help now. But I think that's where usually the problem comes in, where parliament gets sued on passing these bills, because I think your law reform agencies should be the arm that should work together with parliament to ensure that public consultation is thoroughly done. And if law reform tells you public consultation is not done, then send back the bill rather than just listening to the minister and passing the bill. So the question is, how do we build that bridge between the two? In most jurisdiction, law reform is a directorate in the Ministry of Justice, for instance. It's not a body on its own. So often it's very difficult for law reform to make a decision, since it's not autonomous. But now my question is there a way we can bridge that, either between law reform and the Legal Counsel of Parliament, or law reform and Parliament itself? Because law reform only ends at Cabinet Committee on Legislation. By the time it gets to Parliament, there's nothing we can do. The law gets passed, and then you are sued left, right, and center. But then, yeah, I don't know. Maybe somebody can help me there.
Thank you. Good afternoon, colleagues. My name is Salome Sakala from the National Assembly of Zambia. I just wanted to learn from our colleagues here on the doctrine of exclusive cognizance. It seems to be the first line of defense when litigation comes along. You can't challenge the procedures. So I just wanted to learn how other people go about such challenges. Should it just end at that? You can't challenge us, and yeah, maybe if someone could help me on how the best practices when going around that doctrine. Thank you.
Thank you very much. I'd like to thank, excuse me, Sheriff Sam and Solomon for the discussion. My name is Pius Bidivonuha from Uganda. There's a point I want to make or raise, has been touched on by the gentleman from the Kingdom of Eswatini and I think the lady from Uganda, Susan Katono, about the issue of internal conflict or not necessarily conflict, but internal agreements within Parliament ending up in the courts of law. Recognizing the fact that, you know, we always talk about separation of powers, the three arms of the state. In an ideal situation, these three arms should have a healthy friction. They should be always a pulling and push. When there is no pull and push, then there is a problem. I think the system then is not working. Now, and recognizing that, each of these arms naturally will always want to trim the other arm. Again, it's a natural consequence of the push and pull. And therefore, that's why the question raised by the gentleman from Eswatini becomes important and tied into what Susan Katono from Uganda said. Some of the judges that I have interacted with, they always say, it is you people, it is your very own people who bring these matters to court. And as I said, the moment you take matters to court, naturally court will trim you, okay? So how do we then as council, one, do we appreciate that? Do we agree with that? And then number two, how do we help our institutions to appreciate that them going to court? You can imagine a member of parliament deponing an affidavit against their speaker in a court of law on matters that should be handled on the floor of parliament. So is it a question of the rules of procedure? Have we advised to have enough discourse within the institutions to be able to kind of settle their matters between themselves? But again, is it possible given that this is a political environment? Thank you.
Thank you. My name is Sena Achu from Ghana. I wish to get further, I wish you share your experience on the private member bills. My question is to the last speaker from Uganda. Private member bills are, this is something we are taking steps to initiate in Ghana because we haven't had private member bills since our constitution started. What position, you mentioned that the limitation you have is the fact that bills that have financial implications cannot be passed as private member bills or cannot be introduced in Parliament. Our current position is that bills such as Property Rights of Spouses Bill, bills that affect public order, we are of the view that they do not necessarily have, they cannot necessarily refer to as money bills and can pass as private member bills. I just wish to get your experience and the challenges you've had so far. We also appreciate that there's a need for some cooperation between the legislature and the executive. And for us, our position is that once such cooperation exists, it's a good leverage to enable Parliament use law as a means of social engineering. You know, but I just want to hear your experiences so far, the challenges you've had, just to guide us towards the path we are about to chart. Thank you.
Thank you, Nati. Thank you to the speakers. My name is Michael Prince. I am a legislative drafter in the Parliament of the Republic of South Africa. I don't really operate in the litigation space, but there are two observations I just want to make with regard to what was said by both speakers. The one dealt with targeted public participation, and the other one dealt with private members' bills, which is the space in which I operate. In our jurisdiction, we've got laws of general application, and I'm sure that applies to other jurisdictions as well. So we do broad spectrum public participation. We do, however, if we have specialized bills, we do target key stakeholders. So if we have legislation that regulates the legal industry, we would specifically target, in our public participation, we would specifically target the attorneys and advocates, but the public participation is broad spectrum. So there's not only directed at the particular stakeholders. The other issue is on private members' bills. Quite interestingly, our constitution says that money bills, to which the colleague was alluded to, can only be introduced by the Minister of Finance. So we've got 3 vehicles by which our legislation can be introduced in Parliament, through the executive, which is the most common, committee bills, which is a committee of Parliament itself, or private members' bills. But a money bill, which deals with taxes, can only be introduced by a Minister of Finance, which is the executive. Thank you.
Feel free to add, but this is after our presenters have answered questions. Thank you very much. Mr. Mohan.
Thank you very much. I think this is an area which elicits a lot of discussion. I will attempt to answer the following. The first question on Parliament being a shield. I think what you will notice in many of the parliaments have noted with the Directorate of Litigation, it also has a compliance aspect, so that you come up with preventive ways. And one of the ways is working very closely with the committees, because many of this is house-based. A lot of this litigation arise from the house-related work. So we work very closely, like on matters to do with impeachment. One of the legal counsel and litigation must sit with the committee and the legislative drafter, so that whatever they are doing, they are anticipating a litigation can come out of it. And we are doing the same also in bills when you are considering legislative proposals. We also have this in mind, that you have a checklist of things that you must have. And I think our committees are on this. Our Directorate of Legal Services in the houses are also dealing with these issues. And I will invite them if they have something. So that finally what you are anticipating is at the end of it, you don't want, because many of these cases, by the way, when they go to court, they are frivolous. The court finally ends up dismissing. But there are key ones where you find maybe a critical area was not considered and not addressed, and the courts may end up nullifying the legislation. So on the question of, Susan said, what are we doing to prevent the Parliament? I think coming up with the preventive measures, and I think in designing, documentation, designing a style where you already anticipate you could be taken to court. So you develop documentations and your engagement, and then you already have schedules of what you are dealing with. Swaziland litigation from within, I totally agree with you. Because a lot of our cases, especially the big litigations, you find a member lost a motion or an amendment in the floor, then they go and sponsor a case. You'll never see them, but through your engagement with the litigation, the petitioners, you'll actually come to know the member who sponsored that case. Sometimes they even steal the answer from, I'm sorry to use that word, they sneak in documents from Parliament, because the document gets, about illegally obtained evidence. So they will take it there, and it will become now public consumption for the petitioner, who will finally now move the case. So you will start wondering, how are my documents getting out there? But actually these are members who are interested, but they lost through the debate, and they are sponsoring. Many of the issues touching on parliamentary powers and privileges, you find the member lost, like maybe is removed from a committee by the party, or maybe by the committee itself. They go to court and they are challenging the powers of the speaker or the powers and the privileges committee to deal with them. So it is true, it's a live issue, and I don't think there's anything we can do with it. Quickly, as on the issue in Zimbabwe, linkage between the law reform and the Parliament. We have 3 layers, I think, in the legislative process. One of them is pre-publication scrutiny. Before any bill comes to Parliament, the sponsoring ministry has to undertake pre-publication scrutiny, where they take these bills or the proposals to the public through the ministry or the office of the Attorney General. And I think that is the level in which the law reform comes in. The level of our participation during public participation, the law reform is also not prevented from also undertaking the exercise. And in Kenya, we have a law reform commission, which is also, in fact, many of the cases you find, the law reform commission is sued as an interested party for failure to help in the enactment of that law. That is the allegation against the Law Reform Commission. And then the third tier is where you find, even after the bill has passed through the enactment process, there is still a level for intervention through the presidency, because through the presidential reservation, they can still intervene and have the bill come back to Parliament for reconsideration. So I think this process of engagement, a lot of it you find, the members of public have not understood well, and this is in many jurisdictions I've seen, at what layers of engagement do they have and what is their role. Some of them wanted to get the legislative role so that whatever proposal they present, it becomes the law. But you know, you know many, and I've seen it in reports, where you find where the committee reports as observations which are finally not taken as the final committee recommendation. Those observations, the courts wanted to be swayed on that direction. So the last one, so that I can allow my colleague to comment, is on exclusive cognizance. It is true, many courts, and you'll see from my presentation, are exercising restraint. They say this is a matter under the powers and the the Parliament was properly seized off. And I think the way they dealt with it is correct. But you find some courts are going and what you incorporate in company law, we call the opening the corporate fail. They say, but although it was a matter under the powers and privilege, the various processes address the issues of legality and the constitutionality. So now you find they are getting inroads into the powers of the House. So what would I propose? I think the issue, I think Parliament needs to stand guard. And every time when you are undertaking any process, you know that this is a process which could end up in a court of law. So you are always on guard for your processes. Thank you.
I want to start where I stopped. As regards the exclusive cognizance, where I come from, the courts have held firm that they will not interfere in the workings of the legislature. However, they've got the power to interrogate the outcome of the work of the legislature, especially for constitutionality and breaches of the rules of procedure. So if you want to protect yourself, just make sure that you comply with the Constitution and the rules of procedure. Otherwise, you invite them in the arena of legislation. The gentleman from Ghana talked about the sword and the shield and what we do. It has increasingly become acceptable that one of the biggest roles of legal counsel to parliaments is to ensure compliance. And this is preventive. Because if you comply with the Constitution, with the rules, you assess the risk and mitigate it, then there will be no suit at all. There will be no suit to be frivolous, to be thrown out. So that's one measure you need. Assess the risk and mitigate it. And that's where the preventive role comes in. If it fails, that's when you go for the fight. And that's part of your role. Don't wait for it at the tail end, because there are cases you'll never be able to defend. Eswatini, the frustrated members looking for another avenue to speak out. That is true. The case I gave you in the Supreme Court was actually filed by members of Parliament, challenging the legality of the actions of Parliament in passing a law that was amending the age limit of the president. But there are two considerations. One, the freedom of speech of these members, and two, the legislative role that is expected of a parliament. How did we end up where we did? There is this term called filibustering. Guys will come here and they'll make sure you do not debate. They will make sure you do not debate. These guys were standing up every time and singing the national anthem for 2 hours. Parliament has got a constitutional mandate to legislate. Like it or not, they have to do the work. And at one point, the Speaker has to make a ruling. And that ruling must be reasoned and backed by the rules of procedure. So, do not fear to go to bed because you fear you'll dream. These things have to be done. As long as you take the necessary measures. The enjoyment of rights of one section shouldn't be at the expense of another section. A House of Parliament is a house of persuasion, a house of speech, and everybody deserves their day. Namibia law reform, what we've done back home is that the Law Reform Commission has been invited